Friends, as you are aware that last week we achieved a milestone and we have reached our 200th webinar. We have celebrated last Friday on 20th December, and it was a people from across judiciary, government, uh, SEBI, MCA, IAS, IPS, industry and professionals came and they addressed our gathering. Friends, that day we realized that in last 4.5 years, we have achieved this milestone of 200 webinar continuously. We organize every Friday 4 to 6. And then we realize that yes, something different we have achieved. And it's a really satisfaction to all of us, the entire corporate professional team, that in 200 webinar, we started from 500 members participation in first webinar to we have reached to 1,35,000. We started with 7 speakers in first program and we have reached to 300 speakers collectively in all programs. And then we have received till now 5,000 more questions in each and every webinar collectively, and we address this. And the most satisfactory point was also that we have created some impact on the entire aspects, like we have educating and dissemination of knowledge, resolving queries of and doubt faced by industry and its professional, connecting regulator with participation to bridge the understanding gap, deliberation on consultative paper, which was not a reactive, but it is a proactive approach. And whatever feedback we have received, we have submitted to the regulator. We have sharing suggestions to government and regulatory body on different topics, developing knowledge repository in the form of FAQ, queries, videos, and discussion, which is available on YouTube. Promoting and propagating good governance, because our topic focus is that always how we can create the good governance in the corporate world, and correcting established between participant, speaker, and organization. That was a target which we have achieved. We have created a platform where lots of things relating to SEBI, related to MC, related to IBPI, it has come out very well, and various subjects we have discussed and finalized. Now, this is the achievement we have done in last 4 years out of these 200 webinars. And then in the last webinar, we have committed to everybody that this journey of sharing knowledge will continue, and we will do our level best to create better platform, improving each and every time whatever we are doing. In next webinar, we'll try to do better. So friends, I welcome all of you today and thank you joining, and look forward to engaging an insightful discussion today. First, my thanks to all my learned speakers, then the participant. As you are aware, the SEBI has changed, continuously changing various things, and SEBI LODR is one of the major reforms or major changes are taking place every time, because there is a section governing with the corporate governance. So SEBI is trying to improve transparency, ease of compliance for listed companies. Key highlights which they have brought out in this is strict disclosure requirement for directors, key managerial personnel, mandatory appointment of whole-time compliance officer as key managerial person, streamlined integrated reporting and updating of the definition of material subsidiaries and senior management. Other amendment address related party transaction, board composition, secretarial audit, and promoter reclassification. The amendment also simplify financial reporting timeline, enhance digital access of annual report, and revise newspaper publication norms, ensuring alignment with modern governance and compliance standard. That is the plan which has taken place and which SEBI has come out in their LODR. Simultaneously, there was one more change other than this LODR. SEBI in board meeting on 18 December, they have brought out various changes. But two changes are directly related, which are very important. One is the focus on ease of doing business in respect of business responsibility and sustainability report, BRSR, and review of SME framework under SEBI and ICDR regulation. So today, what we will discuss, first, we will take up insight into the amendment of LODR regulations, their implication for the listed companies. Second, we will discuss insight into significant amendment of SEBI-related BRSR and SME framework. Friends, as you are aware, that we are doing all these things for the creating an awareness, creating the discussion on certain issues where there is a confusion. People are sometimes not clear on some aspects. So we want to discuss these issues and clarify doubts of our members. So today I welcome our learned speaker. First, I welcome Savitri Parikh. She's having over 30 years of experience in corporate. She's a company secretary and compliance officer, Reliance Industry. She has worked in various sectors, including manufacturing, private, media, textile. She's a specialist editor of Ramaiya Guide to Companies Act and general editor of MC Bhandari Guide to Complaint Procedure. Savitri is joining shortly, and she will discuss all the points relating to this. So I welcome Savitri in her absence. Then we have Sanjay Gupta, is former company secretary and chief compliance officer of Indigo Airlines. He has more than 34 years of experience in corporate secretarial, legal, regulatory compliance, and corporate affairs in large and renowned business group, including Indigo, RP, Sanjeev Goenka, ICICI Bank, Reliance, Birla, JP, and DCM Shriram. I welcome Sanjay for our program. Then we have Anjali Agarwal, partner head capital market. Then Ankit Singhi, head corporate affairs and compliance, corporate profession. And Manoj Kumar, partner head M&A and transaction advisory. Now, friend, the structure of program, and then we have Nitesh Latwal, associate partner in corporate profession. So structure will be like this. First, Ankit Singhi will tell the important amendments on LODR regulation. And in the LODR regulation, reclassification of promoter, Anjali and Manoj will cover, and proposed amendment to SME IPO segment, Manoj will cover. So today, what we want to do, we want to change the slide. Earlier, we were doing the complete amendment which was taking place. We were one by one explaining. But this time, what we'll do, first amendment, respective person will tell that what is today and what is it was earlier and what will be the impact, and then queries. And I will ask the answer of different queries which is raised from person from industry and other professional. So we will come out like sometime what is happening, reading can create confusion, like one step below the board. So sometimes people are confused what it means. So we will discuss this and we will give clarity to everybody that what it means. If something on SME IPO, which is there earlier, what was there, now what is there, and how it will impact. So the two types of thing will there. One is the law is clear, but there is a multiple questions, multiple doubts in the minds of people. And second is the law is changed and what will be the impact. So all these points we'll discuss. So without taking much time, I will request now and request Ankit Singhi to give his presentation on first LODR. And then in the each section, you have to stop. The questions are already there. And participant have any question relating to the questions, please write to us. And if the topic is, we have completed the topic, so all other question, general question or question which we have already discussed, we'll take up at the last. So what I will start, Ankit, please give your presentation. Ankit, you have to unmute yourself.
Hi, good evening to everybody.
Good evening.
Welcome you to the 201st of webinar. And I was saying that my friends in North India would be feeling the chill as because of a very rainy season, rainy day today. So, as Sir mentioned about the webinar's title, that we would be discussing recent amendments in SEBI LODR regulations and certain important announcements at the SEBI board meeting. So, with respect to LODR regulations, Sir also mentioned it's the lot of reforms, but I also say it's a very dynamic regulations subject to multiple amendments over a period of years. And the last amendment which we are discussing today, it also started with the consultation paper, I think, being floated in June 2024 this year, subsequent to which the suggestions were received, and SEBI in its board meeting held on 30th September approved the all amendments to the LODR regulations, which were now notified by way of notification on 12th December. And there are multiple amendments across the LODR regulations. Mostly regulations are because the mandate of the committee to work in two areas where ease of doing business can be brought. And if you see in terms of overall amendments, overall scheme of things, I think the amendments tend to bring a lot of ease in terms of compliance. And a lot of things have been proposed in by way of combining filings, rationalizing disclosure periods, which will definitely make jobs of compliance officer much easier in times to come. So to start with, I think first and fundamental is the most talked over amendment in the LODR regulations, Regulation 6, which talks about the role of a compliance officer. And there are three important amendments in the Regulation 6 with respect to the Office of Compliance Officer. If you read the discussion paper or the report of the working committee, while deliberating on the role of the compliance officer, it has noted this fact as part of the report, that it found that compliance officers were not finding their position important enough in the company to be in a position to guide or advise board, or at times their reporting chains were like that they are reporting to the CFO or to the legal head, and there was a need of giving much strength to their position considering the obligations that have been cast on them under the LODR regulations. So considering the same, the committee suggested three amendments to the position of the compliance officers, and all these three amendments are significant. So we'll discuss one by one. So first is that it talks about the compliance officer shall be in the whole-time employment of the company. So in case of a compliance officer, the requirement of a listed entity is to appoint a qualified company secretary as a compliance officer. It is not necessary that the company secretary of the company needs to be a compliance officer. It can be any person else apart from the company secretary to be a compliance officer, but that person shall also be a qualified company secretary. So while under section 203, where company secretaries are appointed pursuant to the mandate of the law, there is already a requirement of those being in whole-time position. Now, considering that there may be a case where the company secretary is not the compliance officer, or there may be some other person who is the compliance officer, law very categorically says that if there is any other person other than the company secretary, he has to be in the whole-time employment of the company. It means that he cannot be on a contractual position, he cannot be on a part-time position. He has to be in the whole-time position employment of the company, considering the role which he enjoys by being of compliance officer. If the company secretary is the compliance officer, it doesn't mean that there is an embargo on he being taking similar office in the subsidiary as a company secretary, because there is a subsequent provision in the Companies Act which allows you to take such position in a subsidiary company. Second and most significant, it talks about that the compliance officer shall not be one level below the board of directors. So this is a very significant change. And the report of the working committee very categorically talks of strengthening the position of the compliance officer to put him a position where he sees that he enjoys that position within the organization, so that he can freely guide the board of directors and other key managing director, and to exercise their powers within the LODR on all various governance and other related matters. There was if you see in terms of one level below, and there is another important position which is called senior management, which talks about that senior management being part of senior management or core team, but and they are also one level below the managing director, CEO, or manager. So generally, when we talk about a level, it is more in terms understood in terms of hierarchy and the way they will be to whom they would be reporting. So if it says in terms of senior management that one person one level below the managing director, CEO, or manager, it means that one level is reporting to that managing director, CEO, or manager. In my opinion, similarly, when they says compliance officer shall be one level below the board of directors, it means they shall be reporting to board, but board is a collective body. They cannot be reporting to the entire board. They would be a company secretary. Being a company secretary is always responsible towards the board, but he has to report to something in terms of administrative functions, a lot of things. But I believe that person shall be someone who sits on the board. So it can be either the managing director, it can be either the executive director. So in my view, when it says one level below the board of directors, it says that your position is just one level below the board. So it will give you that confidence, motivation to exercise your judgment, your rights freely in the organization. And then you are reporting to someone who sits on the board. In most of the cases, it will be either the managing director or the whole-time director. Last is he should be designated as a key managerial person. So if he's a company secretary of the company, he's already a key managerial person. The term key managerial personnel also gives the power of the board of directors to define somebody one level below to act as a key managerial person. Similarly, compliance officer being one level below the board of directors can also designate such person as a key managerial person within the ambit of the Companies Act, which talks about of the key managerial person. So any compliance officer, whether he's a company secretary of the company or not, or he's just a qualified company secretary, he has to report to somebody on the board of directors, shall be designated as a key managerial person if he's not a company secretary of the company, and shall be in the whole-time employment of the company. So these are the key points that one need to consider it about while considering the position of a compliance officer. Sir, this is an important thing. I think we can take views of Mr. Sanjay, and if Savitri ma'am has also joined.
Okay. Ankit, first of all, I just want to give my view on this. The When this particular amendment came, then there was a too much discussion in the circle of, specifically in the company secretary circle, that what it mean or below the one level below the board of directors, and how it can be, it is an administrative poll, whether it's a administratively you are reporting, or so many issues came. But if I'm not going to that part, because sometimes when you go in detail of certain things, the basic concept missed out. So my simple point is, what is the intention of law? What in law wants? So we have to understand this point. So simply, the regulator wants. If you remember, long back, there was a meaning of compliance officer. Compliance. They were saying compliance officer should be there. So who should be compliance officer? That was not clear. And anybody was taking the point that anybody, they were giving name and he's my compliance officer, whether he's a qualified CS, lawyer, chartered accountant. Sometime in companies, out of three also, they were making a compliance officer because there was no clarity. And if you remember that when the public issue was coming, then they were mentioning the public issue, that compliance officer of the company. So that is also not clear. People were giving any name, anybody's name they were giving. Now we have to understand the regulator what he wanted. The like a auditor of financial, like managing director, everybody has a specific role and they are following this. Same type compliance, if you see LODR, ICDR, SEBI law, MCA, Companies Act is nothing but a compliance. So the question is, who is doing compliance? So the compliance is slowly it is cleared. Companies Act cleared first, then SEBI law cleared that compliance officer means company secretary. And now it is very clear the compliance officer means company secretary. So this point, wherever compliance officer is word is coming, is a company secretary. And that is also a KMP, which is already decided by the Companies Act. Now the people are asking one level below the board. So sometimes I'm thinking that I'm hesitating to take that responsibility. Or sometimes people are thinking, are you giving too much to me? Okay. And sometimes people are worried also. Savitri has also come. So she will be the right person to give this answer. So in my opinion, it is a golden opportunity for professional, specifically company secretaries, those who are compliance officer. SEBI is saying you are not only compliance officer, not only KMP, but you have to report to the board. Now they are giving some power. Administrative things, other things was always there because that was a complaint of company secretary profession that we are reporting to CFO and the CFO is reporting the board. So our position is diluted. My position is regulator is saying you are the boss now for compliance and you have to report directly to the top people. So it's a everybody should read very clearly and very cleverly also that now your position is enhanced. You have to report for compliance to the board and board will discuss. Now, before I will add something, I will ask Sanjay, then Savitri is also clearing. Sanjay, what is your view?
Pawan, actually, I agree with your view. When the regulators say that the company secretary, the compliance officer has to report one level below the board, sometimes things become little confusing. Also, what happens? Everybody is reporting to the CEO of the company, and CEO is not on the board. So in that case, things become difficult because that is reporting to a person who is not on the board of directors. So what it should be, and especially in the case when the managing director is not looking after day-to-day affairs. Basically, let me talk about the Indigo case. In Indigo, the chief executive officer is not on the board of directors. The managing director is the promoter of the company, and everybody else, as part of senior management, is reporting to CEO, not to the managing director. Then what happens to company secretary? If he also reports to CEO, whether this is actual compliance or not. Sometimes things become confusing, but in my view, because the CEO also sits on the board for every meeting, if company secretary is compliance officer is also reporting to the CEO, I think this is a proper compliance. We should not go look into compliance from the technical point of view, from the practical point of view also. Because in any case, CEO is not something who is not on the board, who is not there in the board meeting. And board is a conclusive body, company secretary cannot directly report to the board. It means there has to be some person in the company to everyone who is part of senior management is reporting, because that's a proper compliance. Second thing, this is also the job of the company secretary to tell the management in those cases when he's not, as of now, reporting to the CEO or maybe to managing director, to tell him that I'm not talking about my position only. This is position of compliance actually. The regulator wants it. Things have to be changed. If you don't do that, company will be on the wrong side of compliance. Because that convincing job company secretary has to do, he has to be confident enough to convey this point of view to the board. This is my point of view.
Okay. Ankit, just tell me, they have given one not more than one below the board of directors. Suppose they have given uh, not more than one. Why they have written more than one? Is there any reason if they are seeing one level below the board?
So, sir, I believe the reason is that there are multiple levels within the organization. So, generally, as sir also mentioned, that various company secretaries report to CFO. So, then there is a board and MD, then there is the CFO, then it comes the company secretary. So, it goes one level below. So, when you say one level below the board, it means just after the board, you are positioned there. And then you report to somebody who is on a parallel with the board.
Okay, now question is, in some companies, there is a big company and there is a hierarchy, and in the hierarchy, company secretary comes lower. Okay, now by amending this law, no doubt he can sit in the boardroom, he can note minutes, he can do this, but now the situation is totally changing. So do you think that any company which has a junior company secretary, as per their hierarchy, he comes under third category, say first, second, third. So he will jump to the other category and do it?
I think intention of the law is like that only because, as I mentioned, the report also talks about this fact that in many cases, company secretaries are reporting to legal head, who is much level below the board, who is even after MD, and then there is the CEO, then there is the legal head, and he reports to them, which is making their position not easier. It's difficult for them to exercise their powers. So therefore, it is in order to strengthen their position, it is important to take up their position above them and place it just before below the board. So that is the one of the things that the committee noted while deliberating on this point.
Okay, okay.
Oji, I would like to add something here. In fact, that is a very important point. See, when they say one level below the board, this is not the question of rank within the company. Rank means whether he is a manager or senior manager. This is not question of rank. Because
Yes.
rank will be given based on the experience only. If a company secretary is just 5 years old, and the people who are vice president, who are reporting to the managing director, they are say 25 years old. So that person cannot be given the position of a vice president. Question is of reporting actually.
Yes.
Because with respect to the level, his report should be to the managing director or to the CEO of the company. This is my view.
Sir, in many cases, there is also grades on which remuneration and various other things are also defined, particularly in case of PSUs. So
Yes.
that will definitely not mean that you take him just below the pay grades of all of them and make him sit at the top. Then there
Certainly,
definitely be
yes.
a lot of issues.
Hmm.
I think
Okay.
it's only because of reporting.
The if I use this particular point and people are confused, there was a section 178. Okay,
Yes.
one level below the board in section 178, and the same definition get borrowed from the requirement under LODR for placing the remuneration of SMP, senior management person.
Hmm.
We all have well established practice through our NRC policies on this effect. So in simple term, you will now be a designated SMP as per your current definition and organizational structure. This was the intention, that you get access to UPSI like all other senior officials, and then the obligation of disclosure can be met easily. So the point is very, very clear that we should realize this point, that confusion is there. People are, but regulator is very clear. If you are appointing anybody as a company secretary or he's a compliance officer, he has to be not one level below the board. So are you appointing junior or are you appointing senior? He has to report to the board, and board wants to do directly. No doubt administratively something can come in between, but this is an opportunity for all of us, that the new opportunity has come, that the regulator is saying the enhancement of profession of company secretary should be up and they should report to the board. So tomorrow there should not be hanky-panky that it is not informed, it is not. So they want to make this institution as a separate institution in the organization, that all related compliance, related disclosure, related things should directly be his responsibility, and he should not take chance that I'm not able to get information and that's why it has happened. So you will sit in the boardroom, you'll get all the information. It is your duty to report, and you have to do whatever position you have. That is separate part. Whatever salary you have, that is a separate part. But you, by designation, uh, you will be called as a the person who is compliance officer. And I remember when I was giving lecture in Institute of Company Secretary, I was always telling uh, the one example to everyone, that this is only profession in the country which is day one. If you are company secretary, or if a person in the company who is a 10 years or 15 years old, but you as a designation, you are a parachute professional who is landing on the rooftop of the company and directly going to the boardroom. So that was the beauty, and this is not a new thing which was earlier. Only thing is the regulator is doing, कि भाई now you comply this. So I'm saying, and I'm creating an atmosphere like this, that nobody can stop you, and you should not say I was not aware or I have not done this. So you are giving more responsibility and more authority also. There was a recently one issue has come, and SEBI chairman in one meeting has she has told that professional company secretary are saying that you have made responsible for everything, but our power is less. So I think it is in the same direction. SEBI is saying you are providing more responsibility. Let's take a more authority also. So this is authority which you have given. Now use this authority and do something great. This is my view. Savitri has joined and she will come back again. Anjali, you want to say anything? Some some questions which you have. Ankit,
Can we move?
some questions which you have some answer we have
I
given.
think we have given almost all of them.
Yeah.
I think. So now we'll move to other things. With respect to amendment in Regulation 15. So while in terms of the requirement of applicability of CG provisions, companies having paid up capital of 10 crore or 10 and net worth of 25 crores, they were supposed to be exempted. They are exempted from the requirement of compliance of the CG provisions if both the conditions were met. But in the proviso to Regulation 15, where it talks about that if you how you can claim the exemption once the provisions are applicable to you and you continues to be out of these two limits, like your paid up capital and net worth becomes less than up to 10 or 25 crores, and then you continues to be meeting it for a period of 3 years, then you can again claim the exemption. There was a little anomaly that the term that was used, that equity share capital or net worth, and in a recent said judgment they said that it is or, it has to be read not as and, while the applicability condition was and but exemption conditions was or. So SEBI has now also changed this to and, that if you have to claim the exemption, you have to meet both the conditions. Equity capital, net worth, both have to be met in terms of the limits. Only then you can reclaim the exemption from the CG provisions. I think it is because of the judgment the amendment has been made. Similarly, in terms of material subsidiary, instead of the net worth turnover is based on turnover or net worth instead of income on net worth. Earlier, it used to be income on net worth. Now it is turnover on net worth. So other income will not be considered. Some significant provisions changes have been made with respect to the position of secretarial auditor. Now, secretarial auditor must be peer reviewed and shall be appointed by the shareholders at the AGM. While the Institute of Company Secretaries has already issued guidelines that for a listed company, if you have to act as a secretarial auditor, you have to be peer reviewed. Now the LODR regulations also mandates the same, that you have to be a peer reviewed secretarial auditor, and you have to be, your appointment shall be approved by the shareholders at the AGM, which was earlier only subject to the approval of the board. Now, vis-a-vis the position of statutory auditor, your appointment is also subject to the approval of shareholders at the AGM. Similar to the tenure of statutory auditors, there is also a tenure which have not been provided by the secretarial auditor. If you are an individual appointed as an individual capacity, you are eligible for one term of 5 years. And if you are a peer-reviewed firm appointed as a firm, that you are eligible for 2 consecutive terms of 5 years, similar to the statutory auditor. These provisions will be applicable effective 1st April 2025. So all existing tenures of the secretarial auditors in the company will not be considered for determining this one-time tenure of 5 years or 2 tenures of 5 each. So existing tenure that you are already in associated with the company will not be counted for the purpose of the new tenure that have been outlined. Another important is that there is a cooling period of 5 years. The new firm must not have any ongoing common partners with the ongoing firm. So there is a cooling period after you complete the period of 5 years or 10 years. There is a cooling period of 5 years. You cannot be reappointed for next 5 years. Board, in case there is a casual vacancy, it has to be appointed within 3 months, and the secretarial auditor serves the office till next AGM. Surprisingly, while the principal appointment requires the approval of a shareholder, in case of a casual vacancy, there is no requirement of obtaining the approval at the shareholder, similar to while in case of a statutory auditor, you need to obtain the approval of the shareholders within next 3 months, but no such approval is required. So when the secretarial auditor's report will be laid as part of the board report, in case of a casual vacancy, that secretarial auditor need not necessarily to be appointment shall be approved by the shareholders, which is which otherwise, if secretarial auditor has to be appointed, the appointment needs the approval of shareholders. But in case of casual vacancy, the regulation doesn't talks about seeking the approval of the shareholders. It only says that the approval of the board has to be taken within 3 months, and it only serves till next AGM. Then, similar to statutory auditors, secretarial auditors services shall be approved by the board. So, if secretarial auditor is giving any other services like certification services of or as a scrutinizer, then all these services will be approved by the board. SEBI will outline certain services which cannot be provided by the secretarial auditor. Like 144 talks about statutory auditor, SEBI will now outline certain services which a secretarial auditor will not be able to provide to a company. Only peer-reviewed company secretaries or partners may sign the secretarial audit report. There is one important introduction here. It says that in case a firm is an auditor, the individual partner also needs to be peer-reviewed, which is not the case now. As of now, in case the firm is peer-reviewed, as per the institute's guideline, the firm is eligible to issue the certificate of secretarial audit or other certificates, but the individual partner need not to be peer-reviewed. As per the definition of peer-reviewed company secretary in the regulations, the regulation now also provides for obtaining peer review by the individual partner of the peer-reviewed firm. How this will pan out, I believe Institute will lay down guidelines as to whether the company secretaries of the existing peer-reviewed firms will be treated as a peer-reviewed company secretaries, practicing company secretaries, or they will have to obtain a different or separate peer review certificate, which is not the case as of now. Because in case of an individual unit or a peer review unit, which is a LLP or a firm, the entire unit is deemed to be a peer-reviewed. Individual partners need not to obtain this thing. Similarly, the SEBI will also outline certain disqualifications. If these disqualifications are with any secretarial auditor, they cannot be appointed as a secretarial auditor apart from being the mandatory requirement of being peer-reviewed. All these conditions have to be met from April 1st, 2025. All the new provisions related to appointment of secretarial auditor, services, casual vacancy, their tenure, all these start effective from April 1st, 2025. So all appointments for 2025-26 financial year will have to be in accordance with the new guidelines that have been laid down as part of the amendments in the Regulation 2024A. There were some questions that we have received while the regulation talks about appointment of shareholders of listed entity secretarial auditors by the shareholders, whether there is also a requirement of obtaining the approval of shareholders of the listed entity for the material subsidiary. In my view, the regulation talks about only about the listed entity. Sanjay ji, you have a different view on this?
Ankit, I think it was just Sanjay.
Yes.
Let me just ask you, because there are so many questions, Ankit. And friends, some questions are unanswered still on the part of this one level below. Let Savitri should join. Then I will ask these questions again. Sanjay, what do you feel the power of secretarial auditor, which was a demand? Now, two very important amendment has come in LODR to enhance the power of this company secretary profession. One is the employment, one is the practice.
Yes.
The secretarial auditor is like, there were a demand that it should be like equal to statutory auditor. His appointment should be by the board and other by the shareholders, and removal is also. So what do you feel? What will be the impact now on this?
I think when we talk about the power of company secretaries, so these two are very significant changes. One is regarding company secretary employment, as you are right. Second is secretarial auditors. And secretarial auditors, this is a very significant change, not only the point of view of power of professional who are in practice, and but also from the point of view of the company. Because for years, the difference was being felt, a discrimination between a statutory auditor and the secretarial auditors. While in case of secretarial auditors, so many provisions were there, and so much value was being given because of their approval requirement, their powers, and so many things. But in the case of secretarial auditor, so much importance was not being given, and their approval was just by the approval of the board and on the annual basis only. By making these provisions at par with the statutory auditors, I think the powers of company secretary in practice has multiplied significantly, and this is also very very far-reaching change.
Okay.
About this question, whether shareholders approval is required for appointment of secretarial auditor or material subsidy. There are different point of view, but I think I'll take a conservative view. Yes, for material subsidy also, now power of approval of shareholder should be taken by the listed company.
Okay, Ankit, do you have any view on this?
Sir, my view is that it only talks about the listed entities secretarial auditor. So only that approval should be taken.
So you mean take it for subsidiary company not required?
Yes.
Okay. So let's uh, any other view of any other person?
So even my view, I'm sorry, sir, I'm on the highway and it's raining badly. There may be some disturbance. But
Okay.
even my view is that the regulation talks about the listed entity, but the appointment of sec auditor of the material subsidiary shareholders approval would be a little tedious task for the company.
Okay.
Sir, my view, Nitish here, sir. Sorry, I'm traveling. So my view is also in line with Sanjay Gupta, sir, because because we are talking about the corporate governance and material subsidy is something LODR also indirectly or directly have the provisions which somehow restrict some material transaction when you are carrying out some transaction in your material subsidiary like sale of any asset or property. You require the approval of the shareholder of a listed entity. So on that premises, in my view, that material subsidiary also, matlab ki the secretarial auditor's appointment in a material subsidiary also requires the shareholder approval. If we talk about the governance norms.
No, no, sir, Nitesh and Anjali, I think Sanjay and Nitesh is on the same view. Ankit and Anjali is in the same view. My opinion is that it is not, because what is happening, first you are starting with secretarial auditor appointment by shareholder in listed company. Now, first it should establish, then they maybe the regulator will feel it will required for material subsidiary also. So I think it is listed company, so it will be required only for the listed company, not the subsidiary company. Subsidiary company is material and non-material is not an important thing. Important thing is that they are beginning something, so it should be. That is view, but
Sir, even the statutory auditor's approval is also not required for material subsidiary by the shareholders of the listed entity. So,
so that's why same analogy will be used here. We should not venture out something which is different. Okay.
Okay, agreed.
Ankit, you have some
Yeah.
questions also. Then I will ask.
This
some.
is the last question. I think it only talks about AGM. This was a question that whether it can be removed in AGM. The regulation only talks about removal at the AGM. Sanjay ji,
No,
any views?
but I think
Yeah.
I think we should not think something different. Suppose some answer is not there. Read the secretary or statutory auditor regulation. So if anything is not clear or confusing and silent, then whatever law is applicable to statutory auditor, that will applicable to
Sir,
here.
in this case, it is very categorically mentioned that he has to be removed at AGM. Statutory auditor can be removed at AGM also. In case of a PCS, secretarial auditor, it says the regulation says can be removed at the annual general meeting only.
But Ankit, it means that
Otherwise, they would have mentioned that A could be removed with the approval of shareholders.
so there is
Very
a
simple.
possibility that EGM or AGM point is they are not differentiate.
Doesn't appears to be that they have inadvertently mentioned AGM, because otherwise it would be very simple approval of the shareholders. They have mentioned with at the AGM.
So what is the logic behind this?
I think since the appointment takes place at AGM, the logic can be the removal will also take place at
So both
AGM.
are the shareholder, both the AGM.
But sir, AGM has its own importance because when you people attend AGM with a different perspective as they attend an EGM.
Hmm.
That is the main. I think that can be the only rationale that they wanted the approval also removal also at the AGM, because once the place where you are appointing him, then you also removing him, because in case of statutory auditor there is also a regulatory approval that is required. So then because your application will be further scrutinized by someone. In case of a statutory audit, secretarial auditor, there is no statutory approval that is required after the removal removed by the shareholders. Therefore, they wanted to make it more tough that it should be only at the AGM. That can be the only rationale that I can see.
Okay. Okay.
But in my view, I think this may not be the intention of the regulator. I mean, this should be shareholders only, whether AGM or EGM. Maybe we can request SEBI to clarify whether this is their actual intention or the intention is to give the power to shareholders only, whether it's AGM or
Yeah,
EGM.
because the regulation says by the shareholders at the AGM. So
Yeah.
it is very clearly saying that it has to be at AGM. We can definitely seek clarification from SEBI, so
I
it can
think
be
this
generalized.
is required clarification, because if some auditor is creating problem and company wants to remove him, they will not wait for the AGM till the time that he will create problem. And suppose they want to appoint somebody, so in place of that person, that how they will do it, because otherwise, who will do the audit of that company?
Yes, that would be a challenge.
Yeah, I
Yeah.
think the clarification is necessarily required, because until the clarification comes, we have to read at AGM only, not EGM.
Yes. Okay.
Then coming to
No,
documents. Yeah.
Ankit, there's few questions which I have to just
Yes.
cover here. What about the sole proprietor firm? It is considered as one term or two term?
One term.
One
Okay. What if the individual firm is acting as secretarial auditor for more than 5 or 10 years? Will the person firm go for rotation in ensuing year, or rotation will be applicable from 2029?
It will be, as I mentioned, the existing association will not be counted.
So it will be counted in 2029?
Yes, from April 1st, when first financial year will be 2025, 26.
25/6, yes.
Okay.
Because the period of appointment till 31st March 2025 will not be considered.
Yes.
Okay. If it is a proprietary firm, then the term will be for one term of 5 years or two term of 5 years.
One term of 5 years, then there will be a cooling period.
Yes, I agree.
Okay. For the new provision which is added, is it justified? Should it not there be term for the continuation of existing secretarial auditor?
That is why they've mentioned that existing term will not be counted. So therefore, they are giving you that leeway that you can enjoy other 10 years or 5 years, as the case may be.
Okay. The tenure of secretarial audit need to be 5 years or one term, or can be less than 5 years?
It says for a consecutive period of 5 years, similar to statutory auditor.
So I think whenever there is a confusion on any terminology, because now they want to say whatever statutory auditor, that is the secretarial auditor. So if there is any confusion, read the statutory auditor point of view, which is now, I think, fully matured. Whether amendment in Companies Act is expected regarding secretarial auditor in line with LODR?
I am not sure whether this amendment is required because it is specifically for listed entities. So there are various things that listed LODR regulations provide in addition to Companies Act.
And I think this is a very clear guideline that Companies Act providing the base, and if it is a listed company, they can add some more requirement. So it is not compulsory that Companies Act has to change, then they have to do. So this will give advantage to the industry or the regulator, and the compliance structure will be better, then it will come to the Companies Act for unlisted company also. That let's see. It should prove. Common secretarial auditor is required for both holdco and subsidiary company?
No.
Though this is not required, but this is always desirable. Like
Yeah.
in case of statutory auditors also, mostly, I mean, if you see 90% of the cases, there is a common statutory auditors both for holding company and subsidiary company. So in line with that, I think that will better practice if the secretarial auditor is also same. And
Okay.
especially in those companies where there are not too many subsidiaries.
Okay. If the listed entity is exempted under Regulation 15(2) of SEBI LODR to comply with corporate governance requirement, then the appointment of secretarial auditor under Companies Act as per Section 204 of the Companies Act 2013 is also required shareholders approval.
Because even the 204 also is a secretarial auditor. It says that appointment of secretarial auditor needs to be approved by the shareholders. But the fact is that in case this regulation is not applicable, then the requirement of obtaining the shareholders approval will also not be applicable.
I agree with your view.
Yeah.
Yes, that's right. Okay. So these are the points on secretarial auditor. And any other person has any other point on secretarial auditor, please write. We will cover it at the last. Okay.
So, shall I move?
Yeah.
Okay, so now talking to documents. Instead of now sending physical hard copies of the annual reports to the shareholders who don't have email ID, companies can send them a letter with a web link of the annual report instead of the hard copy. They can still send a single paper instead of the bulk document. And another important thing, that similar to statutory auditors appointment, there are certain requirements with respect to disclosure in the explanatory statement, like big profile, reason of the fees, justification in case there is a increase in fees from the past auditor. All these similar disclosure will also now be required for a secretarial auditor. So as we are saying, on the similar lines of statutory auditor, there are other things in terms of their disclosures on their appointment. All these things which are required to be disclosed in case of a statutory auditor will also need to be disclosed in the explanatory statement for the secretarial auditor.
Okay, Ankit, go back.
Yeah.
So this
So,
actually,
okay.
yeah.
So in this case, the shareholders who have not provided their email IDs, by and large, are the people who are either not privy to the fact that they are having the shares of the company, or the people who are not having access to the computers. Like Abhi, in one of why I'm saying this is, Abhi, in one of the cases we are doing a delisting offer, and the shareholders, that 1 year period after the delisting, the people are calling us again and again that the shares belong to my father, my grandfather, and I'm not aware how to, what to do about those shares. So even with sending this link, although it's a good move, but sending this link probably still will not help us, or the purpose of the regulator will not be met, because these people are really not aware of what to do with the link as well.
No,
That education is required.
Anjali, here no, this is a green regulation. Mean they want to done away with the physical paper. So now the question is, when they are sending, people are not reading. So that's why they will send a link and you can download through the website.
But
So
why they are not giving any QR code similar to financial results? They should have also mentioned QR code. It's easier to open through a QR code than to write a link.
yeah, this is also good move that you give both the things, QR code and link. This is also this suggestion, Ankit, we can give. So in the next amendment they can bring out.
I think there's
Okay.
one question which arises here. As of now, the provisions that the people who are having their email ID and annual report is being sent through email, they have the right to request the company to ask for a physical copy. So after this amendment, whether that right will still be there or no physical copy will be printed.
I think, sir, this right will still be there.
So
So that
that
means
is not modified.
That
yes.
right,
It is
That
still
right
that
is
there in
still
the
right
there.
would
books.
remain.
It is still there in their books. Company, any shareholder can ask for the hard copy. I think it is 36(1)(c). That is
Yes.
still in the books.
I also
Okay,
believe the same
let's.
way.
The second point, which was there, that further the requirement send the annual report 21 days before AGM has been removed. So for that they should not change the Companies Act also.
Sir, the committee considered this point that this is already, the Companies Act already talks about this fact, and all annual reports are sent along with the notice of the AGM. And notice of AGM is sent before 21 days. So therefore, there is no need of this requirement. The only point I was just thinking aloud about is that on body, in case of body corporate, where in case there is no specified timeline that have been provided, this timeline was basically applicable for them, because for companies there is already a provision under the Companies Act. In case there is no provision in their corresponding acts, I believe there must be, then this would be creating some hardship, that there was earlier a timeline to send these things to the shareholders.
But anyway, this is a good move that the point is that everywhere it is talking green. So this is also a move for the green point that people should not waste. Okay.
Yeah, this is really
So
good.
yeah. So next is reclassification of promoter. So Ankit, you start, then Anjali will take up, and the Manoj will take up relating to
Okay.
some questions on this. Yeah.
Okay. So, sir, in reclassification of promoter, basically they have rationalized the entire process. Earlier, the requirement was to reach out to the stock exchange only after you obtain the approval of the shareholders. They have now changed the process, and the shareholders approval will now be obtained at the end after you obtain the approval of the stock exchanges, because it was found that in many cases after receiving the shareholders approval, the exchanges were not giving the approval. So the entire exercise was not found to be in good spirit, that you spend so much time and then approval was not received by the exchanges. So now they have changed the process. When such shareholder request for a public promoter to public to a board has to consider that within a period of, I believe,
2 months.
next immediate board meeting or 2
Okay.
months, which was earlier next immediate board meeting or 3 months. They have to consider that, and then within 5 days of the board approval, they have to inform to the exchanges. Exchanges within next 30 days have to consider and grant an approval. Within these 30 days, any time that the company will take to provide any clarification or any document, that will be excluded. Once this approval is granted by the exchanges, then the companies within next 60 days will call in general meeting and obtain approval of the shareholders, where the concerned promoters will not wait. And once the approval is obtained, within 5 days, they will effectuate the reclassification and inform the exchanges accordingly. Earlier, the only change was the timelines were different. That for board, it was next immediate meeting or 3 months shareholders meeting, not less than 1 month gap, not less than 2 months gap. So there were certain timelines. So timelines have been rationalized to a larger extent. As a result, the process will be completed in a very short period of time. And since you are going to shareholders after you are receiving the NOC and approval from the exchanges, then the chances of the process not going through will be less, as the main requirement has been fulfilled from the exchanges. Now it is up to the shareholders to give their consent, which is up to them at any point of time, either under the old process or under the new process. So the timelines have been rationalized, much to the comfort of both the companies and to the promoters who are seeking the reclassification. The approval of shareholders will still not be required in case the promoter or promoter group is not in control, or where this is the case arising out of on account of a divorce. Those things remains the same. Ma'am, you would like to add anything?
Yeah. Some basic purpose of this regulation, this amendment is that as per the 31A regulation, the immediate relatives cannot be reclassified. And in many of the cases, it was seen that a request was received from any of the sibling of the promoter, and the shareholders approval, as pointed out by Ankit earlier, the provision was that we have to first take the shareholders approval and then apply to the exchanges for their for their NOC. So usme what the shareholders, we used to go to the shareholder, but then exchange used to say that no, you are not eligible to be reclassified. So as a result of which, there was a lot of miscommunication to the public shareholders and to the public at large. So that is why this amendment has been brought in, that first take the shareholders, first take the exchange's permission. If exchange is okay, then go to the shareholders. If exchange says no, this person cannot be reclassified, he's an immediate relative, he falls within the definition of promoter group by virtue of their shareholding and all those things. So then do not go to the shareholders, do not take the shareholders approval. That's the basic purpose of the entire amendment that has come in. And the other provisions which have been clarified were sort of are a welcome move. Ankit, over to you.
But
Okay.
but
Yeah.
Anjali,
Yeah.
the Ankit and Anjali both should realize that this is a receipt of promoter request.
Right.
Now, in both the cases, they are talking. There are so many companies where some non-relative people are the promoter, and they are holding very minimal shareholding. Now, the laws prescribe that receipt of promoter request. So this promoter request means promoter group request. Suppose I have a promoter group shareholder and we want to classify it. So promoter means promoter group also.
Yes.
So it means that I am a promoter group and I am holding, say, 500,000 shares, which is 0.001%. And I want to create a problem for the company. So till the time I'm sending some request, company cannot remove me. So that problem is not sorted out of the other part. What do you say, Manoj?
So this provision is still not very much clear. I think still it is talking about the request to be received by the company from the promoter, and that they have specifically included the word, including the person in subregulation 3, they have included, including promoter group. So, reclassification of a status of promoter, including promoter group, shall be allowed by stock exchange only after receipt of the application, etc. Whatever the process is given. So everything will now apply to both promoter and promoter group persons, and
No,
hence, and the
Chair, I
clarity
also
is
have a
still not
question.
there.
Yeah.
Yeah, Sanjay.
No. So yeah, actually there is a little confusion, though the intention seems clear that the promoter who is seeking to reclassify his holding to the public, he has to make a request. But I am talking a different situation. Say there are two promoters in the company, and one promoter is in the exit route, and his holding comes down below
Exactly.
10%. He himself has not made a request to reclassify his holding as public holding, but the other promoter thinks that he should not be continued as a promoter. He makes a request that the other promoter's holding should be reclassified as public holding. Can the other promoter make a request? And that is the question.
So plain
Sanjay,
reading.
yeah,
Yeah,
see,
Anjali.
we have seen other cases as well, similar to this, wherein the company feels or somebody is being shown in the promoter group for reasons unknown for years. And the company feels that this person does not belong to us in any way, or the other promoters feel that he should be reclassified. But
Yes.
under the present LODR, there is no such provision. Sir, in fact, we have discussed this that there should be some provision for making an exemption application to SEBI, pursuant to which SEBI, on a case to case basis, should allow such cases as well, because these cases are genuine
Anjali,
cases.
Sanjay has given a nice trick in this. Ankit, is it mentioned receipt of the same promoter
Yes.
who wants to reclassified, or any
Yeah,
promoter can give?
The
I
law is
think
very much right now. The law is very much clear that the
yeah.
application
Seeking
has to be received
reclassification.
from the person who is requesting for
Seeking
Seeking
reclassification.
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 so. It means
That is
that's
the biggest challenge right now.
okay.
Actually, that is
If it is
also
possible that let's say there are two group of promoter, or within the group one person has exited due to certain reason, then the rest of the promoter may make an application to the board, and then with their justification, and it is considered by the board, and then went submitted to the stock
Because
exchange.
this is not a one, but sometimes some regulation are harmful and some regulation are not harmful.
yes.
But this particular thing is harmful because the disgruntled promoter group, suppose they you are bringing out IP preferential issue and they sell the shares, so you are disqualified. Again, you are waiting for 6 months. Again, they have they are selling shares, so again you are disqualified. So this particular point is missed out, and SEBI should come out some solution for removing those people, and they can make a limit 1%, 2%, 3% less than 2% shares those who are holding. So the other group can say, go to the board, go to the shareholder, and then request for removal, because there's no scheme today where the majority promoter can say that this is the super minority person and his name should be removed.
Pawanji, I add further board just to tell the purpose also why this is necessary. You know what happens when there are two promoters or more promoters? There is always shareholders agreement which gives the right to each promoter certain rights in the company, like right to appoint directors or whatever. And the right continues till the time they remain as the shareholders of the company. So what happens in these cases? One promoter want to exit. He keeps on selling his shares and his holding comes down to a very low level, say 2%. But since he's availing those rights, he will never request to make his holding as a public holding. But the other promoter, he is suffering because by virtue of the other shareholder having very small shareholding, he is still availing all the rights. So basically, he wants to make a request, but the law is not giving him right to make a request. That's why I think representation required to be given to SEBI to allow the right to the company or to the other promoter to make a request.
Yes. Anjali, any other point in this?
So that's it. I mean, I feel SEBI should allow for some exemption in these cases.
Okay. Ankit, some questions are there. Just uh, Ankit, somebody has commented the original objective with SEBI, or original object with the which stock exchange are formed is getting enlarged from time to time. The right to shareholders who are the owner of the company are diluted. So he's saying कि owner of shareholders is a owner, and his right is diluted by if you are going to the stock exchange approval first.
Sir, I didn't get the question.
I too.
No, the question saying, they are saying when you are saying NOC from stock exchange, his view is the shareholders every authority. Now you are diluting by asking stock exchange. So the answer is that in merger case also, before filing to NCLT, you have to go to the stock exchange and SEBI. So same thing they want to do in future. The problems are coming. So it is better you take approval from the stock exchange. After doing everything, if you are coming and then stock exchange is saying no, then it say your exercise is becoming irrelevant and your time is also less.
Sir, I think one thing I think we are missing. I think regulation 3, sub-regulation 3A is almost deleted and B is substituted to A. I believe this is the situation. If that is the situation, then this requirement of promoter seeking reclassification would not arise. So that would ease a lot of things which we were discussing just now.
Manoj, read it once, please.
No, explain, Manoj. Manoj, explain this.
Yeah. So I just rechecked the text of the language. So it says that in sub-regulation 3, A clause shall be substituted with the following clause, which is fulfillment of the following requirement. First, the promoter seeking reclassification shall make a request for classification to the listed company along with rationale for request and the description as to how the conditions of B of sub-regulation 3 are getting satisfied. Second, the board of the directors of the company analyzes within 3 months. So all those conditions are there, but the word that has made the application, the promoter seeking, the promoter seeking reclassification word is still there.
It is there.
Again, it is coming. Yes, in the substituted para also it is
So
coming.
we should make this request to SEBI that they should consider that other part also, whatever process is there, but this exemption should not be one way, that receipt or the promoter request.
Right.
If the percentage you can dilute. Ankit, a new person who is relative of promoter acquired share by way of gift from existing promoter need to be added under promoter and promoter group. Is this also come under reclassification of promoter?
No, sir. No,
No.
it doesn't. The law itself says that in case of a death or in case of a gift, the donee and the inheritor would
Becomes
be
the promoter.
reclassified as promoter group, promoter or promoter group, whatever the case was. It won't trigger reclassification provisions.
I agree with that view.
But how this person, the relative of the promoter acquired share by way of gift, so what will happen? His name will be there or not?
No, so gift is I am the promoter of the company. I am gifting it to any relative of mine. So then he or she becomes a promoter group automatically. Otherwise, it's a very simple via media to avoid these provisions. I'll keep on gifting to any distant relatives, anybody rather, without following the provisions of the law.
Okay. Right to heart to be given to those promoter who require to be classified as public before initiating any request by the other promoter. That is right, because that law is not there. Suppose promoter is saying that we want to reclassify this person, is not. So right to heart should be given. That is a valid point. But that is not the law at present.
Yes.
So that would be valid when other person can also give the request.
Yeah. Remuneration promoter who is also executive director need audit committee approval. Does this approval?
Sir, that is a separate requirement.
We will cover that part later on. Okay. Yes. Ankit, next.
Okay.
Next question. You have some questions in this?
No, there is no question that we have received apart from the ones that are there in the chat.
Okay.
So this is usual. In terms of the disclosure of material events, there are certain changes in respect of the reclassification of promoters regulation. Now, instead of filing the minutes of the board meeting, where the board considered the request of the reclassification application, only outcome will be filed. And intimation after submitting NOC or approval application to exchanges, or after receiving shareholders approval, all these needs to be informed to the exchanges as part of the material disclosure within the period of 24 hours. These are not so important. In terms of the IBC companies, where there is a reclassification pursuant to the resolution plan, the disclosure of the resolution plan or of the order of the regulator has to be given within 24 hours, disclosing the fact that promoter will cease to be part of the promoter or promoter group.
Here
And
it is specifically
Yeah.
written that there is no requirement of fulfilling the obligations of Regulation 4, Sub-Regulation 3, 4, and 8.
Yes, because it's
So
pursuant to
clearly,
the
obviously, application from the outgoing promoters is not required here.
yes.
Neither their justification is required.
Then board governance.
Now, Ankit,
yeah.
open offer also, Manoj, open offer, what
Yes,
is the rule?
same provision
Same
is
rule,
there.
sir.
Regulation 3 and 8 would not be applicable. Only
So-
thing is, as soon as the change in control happens pursuant to the offer or the shares of the promoters are transferred to the new promoter, intimation would be given, and based on that, change in control would happen. Reclassification could happen.
And in the offer, it has to be mentioned that you will
Yes,
become the
so
promoter.
that has been already inserted in
Yes.
regulation, sub-regulation 5, that you have to show your intent to become the promoter in the offer document. That is mandatory now.
So if you are giving this intent, automatically when open offer is complete, so
Yes.
when you will be changed, open offer completion
Post
when?
change in whichever is there are two circumstances. If there is a shareholding change, transfer of shareholding from the existing promoter to the new acquirer, then in that case, when the shares are getting transferred, this will happen. Alternatively, if there is no SPA or there is change in control otherwise than SPA, share purchase agreement, then in such cases, the date of change in control will be the trigger date, basically.
Okay. Ankit, next.
So moving with board governance, there is a requirement of seeking approval of shareholders in case a director is appointed within the next board general meeting or within 3 months. Now, there is a specific provision that any time that will be taken for obtaining the regulatory approval will not be counted for the purpose of these 3 months. Appointments made by regulator, courts, or tribunal, they will also not be subject to this requirement of shareholders approval. Sir, in my view, this is while they have mentioned this fact of obtaining the regulatory approval. In my view, the period of 3 months get triggers once the appointment takes place on the board. In case the director is subject to a regulatory approval, the appointment only takes place after you receive the regulatory approval. Till that date, till that time, the approval is not received, the director is not appointed on the board. Since the director is not appointed on the board, the timelines for taking approval in the next general meeting or 3 months doesn't arise in my view. And
Okay.
therefore, the time which was required for excluding this time for seeking regulatory approval, I don't know how much sense it brings in the regulation. It has to be read like that only, even before that.
Ankit,
Yeah,
recently,
sorry.
yeah, Sanjay.
Yeah.
Yeah, and actually, Ankit, what you were saying, I was also confused because since we also face the same problem, but here this was confusing. Like in case of aviation company, the approval of civil aviation authority, I mean civil, that ministry is required for appointment of the director. But once the director has been appointed, the period of 3 months is applicable from that date. After
Sir,
that,
but-
no further approval regulatory is required. This is confusing, in fact.
Yeah, because then in your case, you must be taking the approval prior to the appointment.
Yes.
Yeah, so
Yes.
that is what I mentioned,
Yeah.
because sir, in many cases, board appoints the director subject to requisite approval. But in that case, the appointment takes place only on receipt of that approval. So
Yes,
3
that's
months
very
will only
convenient.
start at that point of time, not before, because the appointment have not taken place.
Yes.
But sir, while they have added this clause in this regulation, but similarly, 17(1)(e), which talks about vacancy in the office, where they say that you have to fill the vacancy in 3 months if it will result in non-compliance of the provisions, there is no such exemption of taking regulatory approval. I think this requirement, this should have been brought here, that in case due to vacancy and you are supposed to take any approval within from any regulator, then the 3 months approval requirement will not be applicable. That will be excluded. They have not brought that point here. I think that needs to be brought here also, where it talks about intermittent vacancy.
No, Ankit, it means that suppose you are appointing somebody and then you require some regulatory approval. So the 3 months period will start when you submit that I want to appoint this person, but regulatory approval is required. So till the time regulatory approval comes, it will be on hold.
Yeah, that is not mentioned in the regulation itself. It has to be. Because
No,
if I
what
cannot
Sanjay is
appoint
saying,
a director without
what's
any approval, sir, what Sanjay sir is saying, it's a different method. They take the approval first and then they appoint. There are many companies who appoint the on the board, but that appointment will take place once you receive the approval.
But
but
let
some,
me also clarify. Ankit,
Yeah.
what you were saying, I think it makes a sense here
Hmm.
because now they are saying that if the vacancy in the any committee like audit
Yes.
committee, NRC, this
Yes.
happens due to any reason other than change of director's term, then they
Yes.
are giving a period of 3 months only.
3 months.
So say I am talking of a case where
Hmm.
the other regulatory approval is also required.
Yes.
Okay. And sometime when you file the application, other regulators say it takes 2 months period or 3 months period in giving the approval.
Or more
And
than.
yeah, more than that. And
Yes.
secondly, before that, if a director resigns in the midterm, so
Yes.
first you have to identify the person, then appoint him. Then
Yes.
after identification, then you have to apply to regulator. The
Yes.
time taken maybe 4 5 months. Then how the
Or
3 months will be compared
yes,
with?
or, that has not been considered here. Instead, they have
Yeah.
considered in the regulation 17(1)(c). I think
Mhm.
the apt period was there in this. But by the way, in terms of the amendment, as Sanjay ji also mentioned, earlier in terms of the vacancies in the committees, no timeline was provided, and
Yeah.
so now they have mentioned that it has to be done within 3 months. In case it is arising on account of resignation, death, or any reason out of the control. But if
Mhm.
it is arising as a result of the completion of the tenure, then on the last day itself, the committees have to be made in order.
Yes.
Some
Yes. Yes.
companies tend to keep the companies like that, committees like that. Once they appoint somebody, then they reconstitute. That cannot be possible. If a director's tenure is ending on that particular date and you are appointing any other director or not, the committees have to be made in line with the requirements on the same
Certainly.
point of time.
Oh, certainly, and this problem happens in case of company where there are
Hmm.
many number of directors. For example, there are only 6 directors in the company and two
Yes.
are independent.
Hmm.
And audit committee has to have two independent directors. So when until the other independent director is appointed, audit committee
Yes.
function will
Cannot
not
be.
complete.
Cannot be
So
function.
in this case also this should be happen that the period of 3 months will not include the time taken by the regulator in giving the
Regulatory
approval.
approval. Yes, that has to be there, sir.
Yeah.
Rightly
I
said.
think representative should be given to
Hmm.
SEBI for that.
So now coming to framework for related party transactions, some important changes have been made in the exempted list of the transactions. Earlier, fixed deposit opening in a related party in a bank account with bank which is a related party was exempted. Similarly, acceptance of current and saving account deposits by banks by a related party will now also be exempted. Similarly, retail purchase by directors or employees from a company or a subsidiary under uniform terms, which doesn't result into a business relationship. So it has to be, if you are doing a transaction with a company as B2C on our normal terms which are offered to everybody, you go to a shop of a company, you buy something, that will not be deemed to be a related party transaction. But if you are doing a B2B transaction, you are purchasing for your own business and entering into a business relationship, that will still be continued to be a related party transaction and requisite approvals will be required. Similarly, earlier, any uniform corporate action taken by the listed entity in context of the related parties was exempt. Now they have changed it to provide that all uniform actions taken even by any related parties where listed entity is a shareholder, then all these also will not to be required to be considered as a related party transaction. For example, earlier a related listed entity comes out with a right issue, the promoter applies in the right issue, it was deemed as a exempted related party transaction. Now, if a listed entity applies to a subscription of an associate or a subsidiary company, it was treated as a related party transaction. If it's a case of a right issue. Now they have said that all related parties, if they're offering anything to their shareholders or a uniform basis, then it will not be deemed to be related party transaction, whether that corporate action is taken by the listed entity or by any of it relatives. So that will bring a lot of ease in terms of the compliances, some of the exempted transactions. Then from the approval, they have now mentioned that remuneration and sitting fees paid to directors, KMPs, senior management, excluding promoter group, are exempt from audit committee approval if it is not material. And no disclosure on a half-yearly basis will also be required. So in case you're paying a sitting fees or remuneration to a director, KMP, senior management who are not promoters, then no approval of audit committee will be required. They have mentioned the term senior management. You have to be reading it this in the context where senior management is a related party.
Yes.
Then there were a lot of questions that many companies are not taking approval of remuneration or sitting fees paid to directors or KMPs or senior management as part of their audit committee process. If there are promoters or part of the promoters group, you need to start taking their approvals going forward. And if they are not part of the promoter group, you can continue to be getting exemption because all these remunerations are already being considered by the nomination and remuneration committee. And with respect to the disclosure, various companies were finding it difficult because senior management remunerations were disclosed as part of, in many cases, they were acting as directors in their subsidiaries. As a result, they become related parties, and remunerations which the companies were paying to their senior management were required to be disclosed in the half-yearly disclosures to the exchanges, which was companies were not finding it difficult because of attrition, competition, and a lot of issues. They don't want to disclose the remuneration of specifically of senior management because KMPs and directors otherwise being disclosed in many other reports. So therefore, I think they have received, basis the representation received from the industry, they have exempted both from the requirement of seeking approval from the audit committee and also from the requirement of disclosing them as part of the half-yearly disclosure requirements for related party transactions. Ratification of related party transactions, similar to the Companies Act, they have also brought a related party ratification requirement of up to 1 crore rupees, which is non-material, within 3 months or next audit committee. And ratification needs to be disclosed, the reasons and other things. Sanjay ji, here I have to discuss this.
Yes.
I generally don't understand the need of the ratification because they say if it is not ratified, it is voidable at the option of the audit committee. So the only thing that I see that in case the transactions which in my view, all the transactions can be ratified, but the transactions up to 1 crore, if they are ratified, it will deem to be not a non-compliance. If it is beyond 1 crore and you can still ratify it, but it will deem to be a non-compliance.
Yes, yes, yes.
That's the only difference I see, because otherwise, when they are transactions, they are voidable at the option of the board, audit, or shareholders. It means they have also right to approve it.
So, Ankit, I agree with your point of view.
Hmm.
You know, the ratification option is always there with the audit committee, even when the
Yes.
transaction value is more than 1 CR.
Yes.
The only difference is there when the transaction value is less than 1 CR. So this will not be treated as a non-compliance if the proper justification and reason for not taking prior approval is given at the next audit committee meeting.
Next
and
audit
audit committee meeting agrees with that.
Yes.
But the only thing is that if the ratification does not happen even in this case, then
Then
the
it's
director concerned or the director giving the approval, he is liable in case any loss is caused to the company. That is very
the only thing that they have also mentioned, in case unfortunately you have 2 audit committee meetings back to back, then
Yeah.
you will be at trouble in case of ratification. Generally, it
That is-
doesn't happen. Generally, it
Mm.
doesn't happen. It happens on a quarterly basis. But in case it happens, then you are in a difficult position.
And the ratification is something which is always there in all the RPT policies of the company. That
Yes,
power
I
is
think
always there
I
with the
think
audit
power
committee.
to approve includes power to ratify, in my
Yes,
opinion.
yes.
Similar to audit committees, because audit committees are also required to approve certain related party transactions entered into by subsidiary. There is now, they've also included a provision that they can give omnibus approval to those related party transactions which needs their approval. And similar to other related party transactions that are reviewed by them, which have received omnibus approval on a quarterly basis, the subsidiary transactions which are given omnibus approval need to be or will also be reviewed. It is not necessary that all subsidiary transactions, related party transactions will need omnibus approval. Only those which exceeds 10% of the standalone turnover will need approval. And in case it is a repetitive transaction, you go for a omnibus approval.
Yes.
Exempted transactions, earlier it used to be between two government companies. Now they have changed it to 2 public sector companies. Public sector companies is defined under Securities Contract Regulation Rules, not Act. It is incorrectly mentioned. It says any body corporate and established under the Act of Parliament or state legislature and includes government company. The committee thought that it's a very wider definition as opposed to a government company. So therefore, they thought to change it. Similarly, if there are transactions between one and the central government or state government on account of statutory fees or account of dues, all those transactions will also be not covered under Regulation 23. Sir, any questions we have received on related party transactions?
Just a minute, Ankit. I think related party either very clear to everybody, but till now,
I think there were some questions that companies were not taking approvals of the directors earlier with the audit committee. I think they can do since this you can take it as more of a clarification position. So at least start doing the approvals from now onwards and can take a ratification from past transactions. Now, with respect to certain voluntarily compliances, discretionary requirements have been added, which provides for appointment of women director, holding more than one meeting of an independent director or a risk management committee. It is important that while all these paragraphs uses the word shall endeavor, shall strive, we need to understand that these are part of the voluntarily compliance requirements. So instead, while they uses word shall strive, shall endeavor, it doesn't mean that they becomes mandatory. If you are complying them, you have to disclose them as part of the CG report. If you're not, it's not mandatory for you, for companies to comply. It forms part of the discretionary compliance requirements.
Yes.
Disclosure of events, other important, regulation 30, some changes. There are some changes in the timelines where it says now if a board meeting ends after trading hours, but more than 3 hours before the next day trading day, the disclosure must be made within 3 hours. In case of multi-day meetings, financial results must be disclosed within 30 minutes or 3 hours after each meeting day as the case. If you're disclosing before, during the trading hours, within 30 minutes. If you're disclosing after 30 hours, after trading hours, in 3 hours. But if you're disclosing in a period lesser than 3 hours to trading hours next day, then within 30 minutes. For example, trading hour starts, for example, at 9 in the morning. If you're doing a meeting at 7 in the morning, within 30 minutes, you have to give the disclosure. This is an example which the committee report also talks about. So if you're doing at 4, timeline is 7. If you're doing after 7, 7:15, 9, 8:15, 9:15, it is within 30 minutes.
So, but Ankit,
Yeah.
here I'll stop. I know those things are very clear, and I think this is a very welcome change and very positive.
There is an
change.
important another change also.
Yeah,
Let me
very, very important change.
yeah.
Especially for those companies who are, concluding their board meeting for approval results after 3:30 p.m. So in that case, instead of 30 minutes, they get 3 hours.
3 hours to
Right?
upload.
Yeah, yeah. So, but only thing is that, like you gave the example, like if the meeting concluding at 6 a.m. in the morning,
Yes.
then the results are to be, results are to be given or
3
disclosure
hours.
events by 9. But if the meeting is concluding at 7 p.m., then the
Then
time is
30 minutes.
30 minutes only by 7:30.
Yes.
Right? That's a discrepancy basically. You are,
7:50. If you're doing at 7 a.m., then 7:30.
yeah, because that's a discrepancy
Yeah.
and very confusing thing. Why
So,
not 9 p.m., 9 a.m. in that case also?
in terms of the timeline, there is another important change that it talks
Yes.
about if there are litigation on disputes in respect of which, excluding tax related disputes, in
Yes,
respect
yes.
of which there's an entry in the SDD, then the disclosure timelines are for 72
Yeah.
hours.
Yes, yes, that's there.
I don't,
Okay.
I'm not able to get the perfect rationale for this. There are many things that needs to be entered into SDD.
Ankit, Savitri has also come
Okay.
because she joined and then there was suddenly there was a meeting. So Savitri, I will what we are doing, we will continue to do this. Then again, I will go to the first part. We will discuss. So this point, they are saying some anomalies or some rationale is not clear. Can you just explain certain points on this?
Sure. So, coming back to this first point of an extended period of 3 hours, if if the meeting concludes after market hours, this is certainly a welcome move because the 30-minute intimation timeline is not applicable. Now, let's assume the meeting gets over at 7 p.m. Then you do have a 3-hour time gap for filing the financial results. Of course, I did hear about the meeting getting over at 7:30 instead of 6:30 in the morning and so on. So actually, the whole purpose is it is presumed that this 3 hours is just to ensure that there is enough time for the market to get the dissemination of news. Of course, one can say that in today's day and age, it gets disseminated immediately. However, one needs to have some reasonable time, which has been taken as 3 hours. So, when you're fixing the time and when you are closing the meeting, you need to be mindful of this. So, let's say, for example, if the meeting is in the morning, then you need to be very careful of the fact that you will have to go by the half an hour deadline unless you are able to disclose it well before the market opens. So, one simple solution is even if the meeting is going on, you disclose the results, but you will only get the half an hour time gap then, saying that the meeting is still continuing. So, of course, when you have a law, you need to look at it completely from a especially with respect to securities laws, you need to look at it from the investor's perspective. It cannot be one where the message gets disseminated just because before the market opens. Hence, the 3 hours has been given as the gap. So, if you're doing a meeting in the morning, ensure that you have a timeline by which you decide to disclose whether the meeting is still continuing or not. You can always write that the meeting is still continuing and go ahead. That's my advice over there. With respect to litigations and disputes, this is a very unique situation where it says where you have entered the relevant information in the structured digital database. Now, the way I look at it, in order to ascertain full facts, you are given an extra time. Now, when you say that the information is being entered in the structured digital database, it basically means that it is something which is material, and once it gets disclosed to the market, it is likely to affect the price, which is the reason you've entered in the SDD, but you don't have full records, full details. Hence, you've been given 72 hours from the time of receipt of notice. Let's assume you've received the notice, but you've not received full details. In order to get the details, you're going to take some time. That time period is what is factored in, saying that within 72 hours. Now, if you have full facts, disclose it immediately.
Disclose it.
If
Yes.
it is one which is getting entered in the SDD. What is very important is in para B, point number 8, which refers to litigations,
Vision.
there is an area where it says that if it is likely to result in a demand. So, if it is not likely, you will not be entering in the structured digital database. Now, if it is taken as contingent liability, you will certainly have to treat it as likely. So these are aspects which will have to be covered, and the 72 hours is an extended time period that you've got. Otherwise, you would have only got 24 hours.
24 hours. Thank you, ma'am.
Thank you.
So, Savitri, here I want to clarify one thing with you. As you said while you were speaking about disclosure to be made to stock exchange while the meeting is still on. Say, for example, the results have already been approved and the meeting is still going on, then we can disclose the results. But the problem which comes is that in making disclosure to the stock exchange, time of commencement of meeting as well as conclusion of meeting, both are required to be given. So, since the time of conclusion is to be given, so how we can disclose and what time we'll write as a conclusion of meeting?
So you will write that the results were approved at XX time, and the
Okay.
meeting is still continuing.
Okay.
See,
Okay.
the
That,
spirit behind asking for conclusion of the meeting is to know as to when your clock stops. So
Yes, that's
here
it.
you're being more transparent in
Hmm.
saying that the company approved at so and so time, the board of the company has approved at so and so time, and here I am disclosing it.
Okay, that means the time of conclusion meeting will be deemed as the time when the results have actually been approved.
Not exactly. You are
Hmm.
saying the meeting is still continuing. Please
Yeah.
mention that. And with respect to conclusion, even in XBRL, if you write the time, clarify saying that the meeting is continuing. And in your PDF also, you're anyways going to be stating that.
Yeah.
You're saying the board has approved this at so and so time.
Yeah, I think that's the practical solution. Thank you.
Right.
Okay. Ankit, next, because so many questions and we have to take
So
Savitri
I'll move
expert
quickly.
advice also. Yeah.
Yeah. So in this, there are certain changes for acquisition. The threshold for acquisition, which was earlier 5%, except for control, is now been increased to 20%. Similarly, any change when you're holding any shareholding in a company which already been disclosed, any change earlier the change was 2%. Now it has been changed to 5%. So if there is a change of 5% or more, then the change needs to be reported. Similarly, in case of unlisted entities, if there is a change, if there is an acquisition of 5% or 2% subsequent change, then there will be a separate disclosure in the, most probably in the CG report, where you have to make these disclosures apart from the disclosures which are required as part of the regulation 30. Similarly, for fraud, they have now mentioned in case of senior management, the fraud requires only to be disclosed when it is in relation to the listed entity. So if in case of a fraud by a senior management, when the fraud is in relation to the affairs of the listed entity, only then the same needs to be disclosed, as opposed to the promoter or key managerial person, where it can be any other fraud.
Yeah.
Then the significant
If you can
amendment.
just
Yeah,
go
ma'am.
back to the
Yes, ma'am.
previous slide, just the one previous.
Yes, ma'am.
So there's an important point here with respect to quarterly disclosures, where it says that are required to be made for acquisitions or changes in unlisted company shares. Now, unlisted company under Companies Act would include debenture listed companies.
Yes.
But under LODR, listed company means a company which has designated securities listed on the stock exchange. And designated securities includes
that.
specified securities as well as
NCDs.
non-convertible securities, which means a debenture listed entity is a listed entity under
the purpose of-
LODR. And when you are referring to this particular provision, while there may be a gap, acquisition or changes in unlisted company shares. So if it is a debenture listed company, then the threshold of 20% technically gets applicable. But I would say it's better to be better compliant from a governance perspective. So take the threshold of 5% and 2%. It's much better that way.
Yes.
Thank you, ma'am. So in case of the disclosure with respect to the penalties, they have rationalized the disclosure requirement, where fines of rupees 1 lakh or more by sectoral regulators or enforcement agencies and 10 lakhs or more by other authorities must be disclosed within 24 hours. And all this, penalties below this threshold have to be disclosed on a quarterly basis. So we are receiving a lot of queries in terms of who is a sectoral regulator and who is an enforcement agency. So, ma'am, there are different views. In my view, for example, for like an RBI, for an NBFC, or a TRAI for a telecom authority will be a sectoral regulator.
Absolutely.
But will SEBI, for a listed entity which is not a merchant banker or a broker, will be a sectoral regulator? I don't think so. It can be an enforcement agency. It can be an enforcement agency. But sectoral regulator is a regulator which regulates the business that you're doing. So it can be TRAI, it can be RBI, it can be IDRA for as such. And then enforcement agencies can be also RBI, it can be SEBI, it can be CBI, it can be ED. All those can be act as an enforcement agency.
Absolutely right.
SEBI cannot come in enforcement agency because enforcement agency definition is very clear and it is not a sectoral regulator also. So will it not come in other authorities?
Sir, but SEBI is responsible for enforcing the regulation on capital market. And listed entities being part of the capital market, it will, because there is no standard definition as such of enforcement agencies. All agencies which are in any way enforcing the laws that they are regulating, it can be subject to various interpretation. But
Savitri, now this point is very clear that people were saying 10,000 rupees penalty, 100 rupees penalty, that all has gone now. Okay?
Yeah, all that need not be disclosed on a 24-hour basis. However, they will find a mention in the quarterly reporting.
Okay, Ankit, next.
But this term is now what being discussed. What is sectoral regulator? What is enforcement agency?
Actually, Ankit, my view is that though SEBI is there to enforce the law of the company, but that cannot be called an enforcement agency. They are definition different. It's different than the other authorities. And yes, I agree that this change is very important because earlier the penalties of fines were not very clear. So companies were at loss to understand how much to be reported. Now this is very clear.
It brings a lot of relief.
Yes.
Sure. Now coming to website disclosures, and now it
Okay,
says
just tell which is important. Otherwise, website
Sir,
disclosures.
on website disclosures, only one thing is important. Now, employee benefit scheme documents also need to be disclosed, and excluding commercial secrets or competitive information which can be redacted. The only thing is employee benefit scheme documents. The only document I can foresee is the scheme itself. And we have seen scheme across companies. Generally, it tends to don't have commercial secrets or competitive information. So in most of the cases, the document itself needs to be uploaded. Is there any other document that you foresee, sir or ma'am, that needs to be uploaded as part of the ESOP benefit scheme document? I only see as a scheme that can be uploaded.
That's right. So in the consultation paper, they have very clearly stated So therefore, it is only the scheme document, whether it is ESOP, ESPS or otherwise.
Whatever the
scheme. So it will only be the scheme document. What is important is if you are redacting any portion, because it is a commercial secret or competitive information, it requires approval of the board.
Yeah.
Yeah.
Thank you, ma'am.
And just one second, just the
Yeah, ma'am.
previous slide,
Yes, ma'am.
website disclosures, most companies would anyways have the profile of the directors. What is now required is directorships
Directorships
and full-time positions.
Yes.
Now,
in companies
there are
and
two
body
specific,
corporates.
absolutely, there are two specific points here. If a person is liable to retire by rotation and is going to be reappointed, we of course companies give other directorships. However, the requirement is only to give directorships in listed entities. Here, since that clarity is not there, you will possibly have to give all the
All
directorships,
directorships.
including directorships of private companies, Section 8 companies, and so on. Now, the other point is on full time positions. The term full time position is also not a defined term. So, therefore, if a person is holding any employment, I personally feel it probably is deriving from this point of not more than 3 directorships, which is there in LODR, and also basically from the proxy advisory reports, where they look at certain positions as full time positions. So that's possibly the reason as to why the disclosure is required. Memorandum and articles of association
These
also
are
is something which most companies would have. These are, of course, the 3 main changes with respect to website disclosures under 46.2. I would also like to add that profile of directors. Of course, directorships in full time is a new one. Profile was not a specific requirement under 46,
yes,
but was always a requirement under 62 for debt listed companies.
debt listed entities.
Yeah.
Transcripts, I think there is some important changes, like presentation needs to be given now beforehand in case of an analyst meet, and timelines of approval on the board meeting on the website have been changed. Transcripts now also needs to be submitted to the exchanges, which was earlier not the requirement. You only need to upload on the website, but now it also requires to be submitted to the exchanges. This is done.
Just one second, just the previous slide once again. In case of analysts, one change which has been made is name of the parties. When you give schedule of meetings, names are not required to be
Yes.
given, which once again comes from the consultation paper.
Post resolution, in case of IBC companies, there have been certain changes, certain timelines have been provided with respect to filling the vacancy of compliance officer COMD within 3 months. Similarly, regulations 17 to 21 will also be applicable within 3 months of the approval of the resolution plan. Timelines for results declaration have been provided in case of quarterly result. If you are declaring a result, if the resolution plan is approved in any quarter except the last quarter, then within 90 days of that quarter, you have to give the result. If the resolution plan is approved in the last quarter of the year, then annual results have to be given only within 120 days of the end of the financial year.
Yes.
Another certain certificates now had been disposed of as a very good measure. Certificate on RTA, intimation on loss of share certificate, PCS certificates on transfer, lodgement, 30 days, all these have been removed. This is an important amendment that now a specific provision have been brought which casts obligation on key managerial person, directors, promoters, promoter group to disclose to the listed entity all the relevant information that is required for the listed entity to ensure compliance with the applicable laws. So this is an important regulation because at many places listed entities need to do a lot of disclosures, maintain a lot of records where information from these people is of paramount importance, and therefore this important obligation have now been very specifically mentioned, because if there is a failure, then penal action or other action can also be taken on account of non-compliance of LODR provisions.
Yes.
Integrated filing, the consultation paper or the working committee report talks about 2 kinds of integrated reporting. One is in terms of governance reporting, one in kind of financial reporting. While the report outlines 30 days at the end of the quarter for all governance related reporting, and for financial related reporting 45 days and 60 days. In SEBI, in case of CG report, investor grievance report, have removed the timelines and periods, so they will be coming up with necessary formats and timelines separately by way of a circular. Now, penal appointment of executive directors for 75 years. There was a set judgment as per which there is no prerequisite of taking the special resolution, I think in order to overdone that, SEBI has now very clearly outlined in the regulations, in case of an individual like non-executive director who is attaining the age of 75 years, the approval before he attains the age of 75 years needs to be obtained, which was the case earlier also, but there was a sad judgment which says that the approval can also be taken at a later stage.
I think this is more of a clarification, just to make it
Yes.
very clear, this provision has come.
In case of disposable of assets by material subsidiary, in case that takes between two wholly owned subsidiary, there is no requirement of seeking any approval of the shareholders. Record date, yes. In case of a record date, instead of 7 working days, apart from the 7 clear working days, record date is now reduced to 3 days. Ma'am, there is an important thing that I want to understand. Earlier, there was a requirement of that there has to be a gap between the declaration of dividend and the record date. Now they have removed this. Can I keep the board meeting date and record date on the same date?
So,
The only challenge I face in doing so is about how it will go to be an ex dividend. Because if I keep it both on the same date.
right. See, if you keep your board meeting, it's only at a board meeting, or of course, you can pass by circulation also. Certain persons may have been granted the authority to fix the record date.
Yes.
Okay. So, what you're saying is, hypothetically, you're saying the record date gets fixed beforehand,
Yes.
and the board meeting is held on that particular day.
Yes.
Okay. To some extent, it seems a little bit of an anomaly, because before the board has finalized, you are saying, fine, okay, for dividend, this is going to be the record date. That, subject to the board approving, I'm finalizing the record date, does not seem regular, although it's not illegal. However, it does not seem regular. So, what happens in this particular case is the board has the meeting, and immediately thereafter you give the record date. Since you only require 3 days to be giving this notice, of course, excluding the date of intimation and the record date, you would be able to meet the requirement of, funding and all
Other
those
things.
requirements which are required. See, typically this particular provision becomes very acutely important for interim dividend.
Yes.
For
Because in case of
final
AGM,
dividend, you do have enough time,
enough time.
and the AGM will only be a prospective date. So it's not so much of a challenge. And today, when we have moved to T+0 in some cases and T+1 in most cases, having 3 days for record date is absolutely sufficient, except in case of corporate action or merger, demerger. That's one where you require a little
The same
bit of
7
more
days.
time.
Yeah.
Yeah, exactly.
Ankit, I tend to agree with what Savitri is saying, because in any case, this number 3 is applicable in case of recommendation of interim dividend. And the power to fix a record date is given by the board only. So fixing the record date as the board meeting date is not a regular thing. I mean, this is an anomaly.
Sir, what many companies were doing when they were giving the intimation about the board meeting date, as part of that intimation, the record date was going in the intimation date itself to save time. Many companies were following this practice. So because earlier there was a gap between the date of disclosure record date and the dividend declaration. So in any way you cannot overcome that gap. But since
Ankit,
now that provision has been removed, so therefore
Okay.
Ankit, just finish fast.
now SEBI important decisions on ESG, certain decisions were taken in the SEBI board meeting. Most of the related to value chain disclosures that were applicable on top 250 listed entities from 24-25 on a comply and explain basis. Now that has been changed to 24, 25, 26. Similarly, assurance have also been changed from 25, 26 to 26, 27. Instead of comply or explain basis on value chain disclosures, now it's a voluntary requirement. It's up to the companies whether they want to do it or not. Value chain has now also been redefined. Instead of 75%, now it is 2% or more of the entities purchase and sales by value that needs to be considered. In leadership indicator, green credits have been issued. Assessment by way of the third party, the ISF standards that have been issued. So assessments can be taken basis that applicable from the current financial year. That are the key changes. Some of the changes on the SME. Manoj, if you can take this.
Yeah, so quickly, I think SEBI has brought up discussion paper where there were several changes proposed in the SME IPO norms. However, in the final board meeting, SEBI has considered only a few of them, and implemented the same. So the first one is relating to the minimum threshold of EBITDA or of a company to become eligible to come out with the SME IPO. So now they are saying at least 1 crores of operating profit in 2 out of 3 full financial year before filing of DRHP is the eligibility criteria. So such criteria was not there in the regulation, ICDR regulation earlier. It was there that the positive EBITDA should be there. That was provided by BSC and NSC, but now it is coming in the regulation itself. Second one is there was no restriction on the size of the offer for sale in an SME IPO, but now they are limiting it to 20% of the total issue size. Offer for sale cannot be more than 20% of the issue size, and that should be, and the selling shareholder should not sell more than 50% of their holding as on the date of filing of DRHP. Similarly, they have also added one condition that the promoters holding, promoters cannot dilute their holding, so promoters shares beyond the minimum promoters contribution shall be released from the lock-in in phased manner. 50% would be released after 1 year from the listing, and rest 50% will be released after 2 years from the listing date. So this is a new condition. Then they have also allocated that the allocation of non-institutional investors in SME IPO, right now it is on the proportionate basis, but they are now proposing it to be on the draw of lot basis. This is also new provision. Next, please. So then they have also restricted the use of the fund raised through SME IPO. The general corporate purpose was earlier it was 20%, 25% of the total issue size, net proceeds of the issue, which has been now reduced to 15% and subject to a maximum of 10 crores. So whichever is lower is the limit for general corporate purpose. Then SME IPO cannot be proceeded for repaying the loans to promoter groups and related party. That is also a condition has been put in place. Then they are also saying that the DRHP of SME IPO was not earlier placed for public comment. Now it will be mandatorily put for public comment for at least 21 days with a newspaper announcement and a QR code in the DRHP. Further, issue of SMEs are allowed to without migration to the main board. So now they are saying there were certain companies which were saying that you are restricting the growth of the company by putting a cap on the paid-up capital of 25 crores. So they are saying if you want to go beyond 25 crores within this 3 years window where you are in the SME board, you can continue. You can do so subject to complying all the conditionalities as applicable to main board listed companies. If you are fulfilling those conditions, then you can take your paid-up capital to any level. So this, though the nitty-gritties may come in the regulation, so we have to see that. Then related party transactions norms are also implemented in SME IPO, and that is a good move. So many of the whole gamut of amendments as were proposed might have disrupted the SME IPO market, but now they have curtailed the amendments and limited it to certain mandatory and relevant things which will be implemented in this phase. I think this is all relating to the SME.
Okay, Manoj, thank you very much. I think SEBI consultative paper was talking about so many things, but they have finalized limited changes. But these changes are welcome change.
Yes.
Let's move on. Okay, so now, friends, we have received 62 out of 32. We have replied. Some questions are pending. So I will request when I'm asking questions, Ankit, very brief you have to give because we are already exceeding time.
Ma'am, sir, I think you can first take, and I think ma'am's
No,
view
I will take relevant questions. I will take to the.
No, on the compliance officer, you can take ma'am's view. That
No,
was
I
an
will
important
take
topic.
Savitri has given her view. Ankit, we have discussed a lot on this issue. Okay. So now there's no need to again repeat the same thing. There is a one question. In case of remuneration setting fees paid to promoter or member of the promoter group, we are now required to take approval of audit committee. Since the provision are applicable with effect from 12th December 2024 for balance period 14-25, how do we take the approval of audit committee?
Sir, we discussed this. The approval was always required. Companies were not taking it or adopting different practices. So you can get it ratified. That's the only thing available as of now.
Okay.
The approval was required since beginning.
Okay, what will be the timeline for CG disclosure and investor complaint redressal?
Sir, it would be from the consultation paper, it would be as same as 30 days from the end of the quarter. I think the format that is of much more should be of much more concern to us, and I think SEBI will be coming up with that soon.
Okay. In view of change in definition of material subsidiary from income or turnover, should be considered the turnover of March 31st, 2024 and give effect to the amendment immediately. For example, appointment of ID in material unlisted subsidiary or the need to be complied basic numbers of 31st March 2025.
24, 31st March 2024, because
Okay.
the amendments have already come into force.
Okay. Ankit, can compliance officer of holdings listed company be compliance officer of subsidiary listed company?
Holding listed with a compliance officer, if he's a sir, I think the objective is not to allow that, but if he's a company secretary, he's already allowed to act as a company secretary in both the companies. But I think the objective in listed entity, if he's not a company secretary, just a compliance officer, I think the objective is to stick to the compliance officer of that company only.
Okay. Following transaction is not considered RPD basis amendments. Retail purchase from any listed entity or its subsidiary by its director or its employee without establishing a business relationship and at the term which are uniformity applicable offered to all employees and director. Should service granted by a company to its director in uniformity with the employee or public at large be also covered to be exempted under RPT?
If it is not a B2B transaction, if it is a B2C, like I am a company which gives, for example, pest services, and one of my director is also using my pest services like anybody else for its home, not for his business, I think it is exempted.
I think similar case applies to telecom companies also.
Yes.
This is
Yeah,
applicable.
telecom, electricity companies.
Yes.
Say, for example, you can't say that in this building I won't use electricity from so and so company. That
So
cannot happen.
B2C on the same terms, this is exemption applies.
And then suppose they are exempting two directors, then they are sending bill but not taking, then it's RPT, na?
Yeah, if they're not taking bill, if they're not taking money, that is an RPT.
Very
Then it is not on uniform terms.
Yeah.
Okay. Whether now the CS of the listed entity becomes the CS of wholly owned subsidiary?
Sir, under section 203, it is allowed.
Yes.
Okay. In case of material subsidiary, turnover is considered. I think this is applicable to all listed or only for the equity and HDLP LV company. These changes.
Sir, HDLV companies are, certain companies are required to comply certain portion of the LODR. If there are amendments in those portions, that they are also applicable on them.
Okay. Every listed entity or its material listed subsidiary shall be undertaking secretarial audit by the secretarial auditor who shall be peer reviewed CS. Does this mean that the secretarial auditor should be appointed for similar term in material subsidiary as it will be appointed listed company?
Sir, in my view, the listed entity, the period are for listed entity, not for the material subsidiary.
Any different view of Savitri and Sanjay?
I fully agree with what was mentioned.
I also agree. It
Okay.
doesn't apply.
It is required to file any general form like GNL2 with ROC for designated the compliance officer KMP in case there is no company secretary for the time being. Ankit?
No.
Okay. For company, SEBI should have come out with some kind of experience. Nowadays, a fresher CS can also. Okay, this is we have already replied. If we consider exemption from respect of related party transaction, retail purchase exemption, whether brokerage fees paid in consideration under retail purchase that is service provided, which comes under the ordinary. I think this we have given answer. It's the same way. If he's not charging, then it's an issue. I am a legal manager having experience of more than 5 years in a public company and reporting directly to MD, sir. Can I be compliance officer if company is not having full-time CS?
If he is a company secretary,
she should be company secretary, na?
He should be company secretary because compliance officer has to be company secretary.
Okay. How the position covered the responsibility here is एक minute. The compliance is okay. This we have given answer. This we have given answer. Is there a proprietary firm with this we have given answer? Whether amendment in Companies Act is expected relating to secretarial audit in line with the LODR, we have already told.
Already answered.
You. In listed company exempted from Regulation 15(2) of the SEBI LODR to comply with corporate governance requirement, then appointment of secretarial auditor under the Companies Act as per Section 204.
Sir, already discussed.
Okay. Only somebody has said the general meeting. Savitri is there. Savitri, the issue is coming that the secretarial auditor can be removed by the AGM. They have mentioned. So so issue was coming that statutory auditor can be removed by general meeting, but secretarial auditor by AGM. Is it a drafting mistake or this is intentional?
No, I suppose one would give a benevolent interpretation here. What they basically would mean is a general meeting, and they've said AGM because the person holds office till an AGM. So, if at all, like in case of statutory auditors, even resignation, SEBI has come up with a very detailed circular. A person cannot just suddenly say that I'm going to resign. Now, with respect to a statutory auditor, it becomes more acute because he's supposed to be giving a limited review or audit report every quarter. Now, in case of a secretarial auditor, it may not be happening every quarter. However, the person suddenly cannot say at the end of the year that I want to resign. Here we are talking of removal. Removal, while the reference has been made to AGM, it can be made even in a general meeting.
Okay.
That should not be an issue. Of
Yeah.
course, from a drafting perspective, they refer to AGM, can be at a general meeting.
Okay. In case of secretarial auditor appointed in casual vacancy, if the company wishes to continue for further term, how will the tenure of 5 years be calculated?
From the AGM.
Okay. What should be the timeline to sending of annual report to the shareholder for the manner as referred in the Regulation 36(1) as they are removed 21 days?
They have removed because it is already covered by the Companies Act.
Exactly.
Okay. What will be the material changes in terms of change of fees from existing SA to new SA? Will the material fee will be the as per Regulation 30 of SEBI LODR?
No.
Okay. Whether secretarial auditor be appointed over a terms of less than 5 years or not?
I think so, no.
Shareholder, okay, this we have governed. The appointment of statutory auditor in general meeting is considered ordinary business under Section 1022 of the Companies Act. It requires an ordinary resolution as per Section 139(1). Is this the same for secretarial auditor? Please explain.
So it will be considered the special business needing ordinary resolution.
That's right.
Yes, that's correct.
A new person who is a relative of promoter, this we have given. Right to her to be given to those, this is also done. Remuneration of promoter who is executive director needs audit
Done.
committee approval.
Already done.
Yes.
Okay.
Good.
Which regulatory governance or statutory authorities are they referring to is a sectoral aspect. With this we have given, we will take the clarification. Actually, sector approval of new director should be prior to approval to the board. That we were also saying. What about retail service do we need? I think this we have given answer. If the related party applies for additional share in the right issue, will it still be exempt?
Yes, I believe that is an that is the option given to all the shareholders.
So you are applying, so there is no.
Yes,
Because if somebody is applying extra share, is there any issue in this?
I
Applying for
don't think.
extra shares, that's a right given to every person in a
Everybody.
rights issue.
Yes, yes.
Okay.
Allotment will depend on how much has been accepted by the other shareholders. For that matter, there is a corresponding exemption under SAST also. However, SAST refers to the shares which have been apportioned under the rights issue to a shareholder. So, what you will need to see is what is the additional amount for which you then will require a disclosure. But going by the principle, it's that right is given uniformly to all the shareholders, and your allotment will depend on how much has been subscribed. So just applying for additional shares, no problem.
Okay. A listed exempted under Regulation 15(2) of SEBI LODR regulation for complying with the
Yeah.
corporate governance requirement is also exempt from applicability of Regulation 23.
कर लिया बात sir.
What is the rationale on excluding relative from retail purchase? B2C.
I think relatives of employees are not related parties. That would be directors के relatives होते हैं, but I think they have only restricted to directors and employees.
Okay. Related party transaction, how one will be decide whether it is a retail transaction?
Anything you can buy, go and obtain like any other customer.
Does the material RPT of the subsidiary company require approval of shareholders of the listed entity? हो गया ये. What is a regulator does not approve appointment of person as a director?
Then you have to apply for some other persons. You have to put the application for some other person.
Okay.
Yeah.
I saw in the slide that independent director meeting with all IDs attending. Does it mean if any one ID does not attend the reason beyond his control, the meeting cannot be placed or will be adjourned or will be counted for the number of mandated under LODR, Savitri?
No, there is no problem. All the independent directors are entitled to attend, and the independent directors are encouraged to attend the ID meeting because it's a meeting only of the independent directors. That does not mean that if one of them does not attend, the meeting becomes irregular or is adjourned. No problem. You can
Yes,
continue.
absolutely.
Okay. When a existing promoter, which is a company, donates gift shares to the public charitable trust, wherein one of the promoter of the company is also trustee, then adding the trust under promoter or promoter group come under the reclassification.
So actually, what happens if a promoter were to sell his shares to a member of the public? The person who's bought the shares will continue to be shown as a public only. Just because the promoter has sold does not make the buyer a promoter group. Here, the question is there is a public charitable trust, which basically means that it's something which is beyond the control of the persons. Now, if this public charitable trust is one which is registered with the charity commissioner and all that, I don't see any issue. Of course, removing it from the promoter group. Now, you cannot show it in the promoter group unless the person was a part of the promoter group. So there is no question of reclassification as outside the promoter group. What is also important is what is the percentage of share capital of the company which is getting gifted.
Okay.
If it exceeds 25%, SAST provisions will certainly apply.
Hello, so Savitri, the next question is if CS is Ankit, if CS is now on the considered one level below the board, whether it is required to approve again by NRC or board in the immediate next board meeting?
Only I think the reporting needs to be changed if there is he's reporting to somebody else.
Okay. Whether compounding fee will be considered a penalty or fine?
No.
Okay.
But
compound fee is treated as a fees and not as a fine or penalty, which is very clearly given under the Mother Act, which provides for compounding.
Okay, Regulation 23 already has already provided 1 crore limit for transaction which are foreseen as part of the omnibus approval. Then in such case, what is the purpose of providing new requirement of capital rupees 1 crore? Was that otherwise available to part of the omnibus approval? Providing higher limit than 1 crore still would have made any sense.
In cases omnibus approval has not been taken.
Okay.
Omnibus is not something which can be assumed. It has to be granted, just as Ankit rightly said. So if you have not taken omnibus, then if it is ratification, the limit has been given as only 1 crore.
Okay. If a company brings out any employee benefit scheme, then the plan is required to be uploaded after shareholders approval. Does such scheme have been secret, which cannot be disclosed to website of the company?
If there is any such information, you can redact it with the approval of the board.
Then we have already, they have given.
Yes.
The board approval is required for reduction.
Yeah, will being designated partner LLP be considered a full-time position?
So, under the LLP Act, you are required to have two designated persons. Now, those are not per se full-time positions.
Okay.
And for that matter, designated persons, designated partners under the LLP Act may not even be drawing remuneration. So, one needs to see as to whether they are in full-time employment of the LLP. For that matter, what is the head under which you're deducting TDS if you're paying them money? If you're not paying them money, of course, not paying money does not mean they will not be in full-time position, but it can be presumed that if no money is being paid, the persons are not in full-time positions and they're just doing honorary service. So it has to be seen in the context of what the LLP document provides.
Okay. Full-time position in bodies corporate include LLP?
Yes, LLP is a
Yes.
body corporate.
Regulation 6 amendment. A person who is employee of parent company is seconded, deputed to subsidiary and appointed as a company secretary and compliance officer. Will that be a still permissible consideration for present amendment? Same view.
I'm sorry, I need to drop off. I have really
Okay.
enjoyed being on the panel. Thank you very much.
Okay.
Thank you,
Okay.
ma'am.
Thank you, Savitri.
In case of change in the definition of material subsidiary from turnover or turnover income, ये हो चुका. The question is related to SEBI meeting minutes. Point number 3.8 of SEBI MB Regulation 1952.
Manoj can take that.
But what is 3.8 SEBI?
SEBI?
What is
3.8. Let me just see. CV
Okay.
3.8.
Can a CS and CFO of the listed entity are the same person in the light of changing now? No, it is
No.
not allowed.
No.
Manoj, 3.8 is with respect to minimum education qualification of company secretary has been prescribed for the compliance officer. So it is clear, sir, that compliance officer needs to be a company secretary or a graduate.
Yes, that is clearly written. Yes.
They have not mentioned about the experience. They have mentioned about the qualification. Tenure of secretarial audit would from AGM to AGM for financial year.
Pardon?
Tenure of?
Tenure of secretarial auditor would form AGM to AGM for
AGM
financial
to-
year.
Yes.
Sir, it would be for the financial year, yes.
5 years.
So 3.8 minimum education qualification. Company secretary or graduate degree in law and post qualification work experience for 2 years has been prescribed for compliance officer. Existing compliance officer may continue provided they have 5 years experience and have obtained the prescribed NISM certificate. This is
Sir, this is relating to MB regulation amendment proposed, not relating to this LODR.
No, Manoj, he has asked only for MB only.
MB regulation,
हाँ.
yes.
So MB regulation is 3.8. So MB regulation is different than the LODR.
Yes. वहाँ पर
RPT
compliance officer, there can be a person who is a compliance officer holding having a qualification of degree in law and post qualification experience of 2 years. That is
Okay.
that is also a condition. Yes.
RPT limit to be increased to 2 crore in view of the inflation. That is some suggestion. A person who is employee of the parent company is seconded, deputed to subsidiary and appointed as company secretary and compliance officer. Will that be still permissible considering the present amendment?
Already replied.
Okay. This is a little bit big question. Employee benefit scheme document excluding commercial secret and such other information that would affect competitive position of the listed entity framed in this. Provided, I think this somebody has
Just a
asked
clarification,
question,
yes.
so he has given clarification.
Yes.
So Ankit, I think there are 70 questions, okay, which we have given reply, and some questions you have given in your presentation. We have exceeded 17 minutes also. So it's a time to close. So friends, any of your question is not answered or not clear, what we are doing, some clarification we will take from the regulator relating to some aspects which we have discussed, including AGM and EGM, including sector regulator and the enforcement agency, another thing, for more clarity. Because the time is going on when the industry standard forum is helping SEBI, and SEBI is referring various things to industry standard forum, and the forum is working out the standardization of various terminology and things. So under this, because SEBI wants to bring out no confusion, so it is better the compliance regime can be good if you comply properly. So thank you very much all Sanjay Gupta, Savitri Parekh and other people. Just I'm showing you our poll. Not more than one level below the board directors regulation single answer based on direct reporting the board of directors 47, based on the organizational hierarchy 22, combination of reporting of hierarchy 30%, unsure 1%. Next, in case of compliance of company secretary as separate individual, do you believe that compliance officer must always qualify as key manager person under section 203, 67 yes, 21
Yes.
no, independent structure of the organization? Next. Whether secretarial audit can be removed at AGM, 38% say yes, 44% no, unsure 18. So it means it requires clarification, which Savitri and other people are saying you can use interchangeably, but there is a confusion. So we have to ask them. Next, ask the SEBI. Do you report the enhanced compliance requirement for non-executive director age 75 and above with terms of appointment and reappointment? Strongly support, oppose. So support is more, is 87%. So that's why it is there. So these are the few polls we have done. So in every program we do the polls. So thank you, Sanjay. Thank you, Savitri.
Thank you.
Thank you, Ankit, Manoj, and Anjali for Nitesh for giving clarification on various aspects. We will meet again in the new year. Happy New Year to all of you. Third, we will meet with a new topic, with a new speaker, with the regulator on some interesting topic which is burning and we want to discuss. Till then, goodbye and Happy New Year. It will the new year 2025 will bring more laurels and more happiness to everyone, all participants, all people surrounding us, and the countrymen and the world. Thank you very much.
So thank you, Pawanji,
Thank
for
you.
providing the opportunity, and